Hello everyone, welcome to lesson 1.2, Robes and Roles. In this lesson we will explore the exciting world of the courtroom, understanding its structure, the key people involved, and how trials work. This foundation is essential as you prepare to participate in mock trials. We'll be covering four main areas. 1. Characters in a courtroom. 2. Understanding the courtroom layout. 3. The adversarial system. 4. The mock trial format. Let's start by looking at the key players in a courtroom. Every trial has several important figures, each with a specific role to ensure the legal process is followed. The judge. This person oversees the entire trial and ensures that the law is followed. Think of them as the referee in the courtroom. The attorney. These lawyers represent either the prosecution, also the plaintiff in a civil case, or the defense. The attorneys argue the case for their clients. The witnesses. The witness is an individual who provides testimony based on what they have seen or what they know as an expert. They are crucial for presenting evidence. The jury. This group of people is selected to evaluate the evidence presented and ultimately determine the trial's outcome. The bailiff. This is always a classroom favorite. This officer is responsible for maintaining order in the courtroom and assisting the judge. The court clerk. This is the individual who manages court documents and the trial schedule. A lot of times in the courtroom, they're also the one recording electronically what is happening if there's no court reporter. Sometimes you might also see a courtroom artist. This person draws scenes from the trial, especially when cameras are not allowed in the courtroom. Specifically for mock trial competition, we have a timekeeper. This person monitors and enforces the time limits for each segment of the trial, ensuring that it runs efficiently and fairly. Now, let's explore what the courtroom is and how it's laid out. It's not just a room, it's a carefully organized space where each area serves a specific purpose. Some key areas you'll find are 1. The judge's bench. This is where the judges sit, obviously, and it's in the very back of the courtroom looking over the rest of the room. The witness stand. This is a designated spot where witnesses give their testimony. Usually it's just to one side or the other of the judge's bench. Sometimes it can be a little bit spaced apart from that. This is a place where the witness can sit and have a microphone to present their testimony. The defense and prosecution tables. This is where the attorneys and with their clients sit. Sometimes a key witness may also join them who is closely associated with the case and given special permission. They have tables so that they can organize their papers, have their laptops, and be able to access notes as needed. The jury box. This is an area for the jury to listen to the evidence. The jury sits to one side usually of the courtroom and have separate seating as an area. A lot of times this will be bordered by a wooden box so that they have a designated space. And then lastly, you have the gallery. This is the public and press seating area. Usually it has pews like in a church. Sometimes they have more sophisticated cloth chairs or other type of seating. So, thinking about that courtroom diagram, let's take a moment to think about why we believe it's organized in this particular way. There's a reason behind every placement and all of the different purposes. It's designed to facilitate the legal process. Take a chance when you can to look at the student guide and make sure you can label and diagram the courtroom yourself. Now let's move on to the fundamental concept between why we have these plaintiff and defense areas. And that's because we have an adversarial system. This is a core principle of the legal proceedings in which two opposing sides, the prosecution or plaintiff and the defense, present their cases to an impartial judge or jury. The prosecution plaintiff presents the case against the defendant. aiming to prove their guilt or their liability. They have what's called a burden of proof. The defense argues on behalf of the defendant, challenging the prosecution's theory and their evidence, and protecting the defendant's rights. This system relies on both sides presenting their strongest case, their arguments, and their evidence, with the judge or the jury ultimately determining the outcome based on these presentations. Think about this. Is this adversarial system the best way that we can achieve justice? You'll have a chance to think about that as we work through activities. Finally, let's look at how a mock trial works. A mock trial follows a structured format that closely mimics a real trial. Here are the key stages. First, preliminary matters. The judge handles any housekeeping issue before the trial begins, such as swearing in the witnesses. Next, we have opening statements. Both sides present their initial remarks, outlining what they intend to prove to the judge or the jury, sometimes telling a compelling story about what they think they're going to be able to prove happened in the case. After opening remarks or statements, we have direct examination. This is when the attorneys question their witnesses to build their case. After direct examination, for the same witness, you have cross-examination. This is when the opposing side questions those same witnesses to challenge their testimony. After direct and cross, and the entire case for each side is presented, you have closing arguments. Both sides summarize their cases, emphasize key evidence, and have a chance to argue about how the evidence should be applied to the law and what the evidence really means in the case. After these arguments, the judge or the jury will have a time for what's called deliberation, which is the last stage. They will consider all of the evidence and decide what the outcome should be. These stages will be the framework for your mock trial experience. I encourage you to open your student guide for lesson 1.2 to study and check your knowledge on this framework. Think about the role identifications, think about how the courtroom is diagrammed, and think about and understand how the adversarial system works. Understanding the roles, the courtroom layout, the adversarial system, and the mock trial format will set you up for success in mock trial. Good luck, and I look forward to seeing you become courtroom experts.